Did you hear me? Okay, so welcome to the session 2B on the new organizational patterns and implication for working time. We have 3 papers and the speakers are coming from East European countries, namely from Poland and from Hungary. And the rules of the games are that each speaker has 15 minutes to introduce his paper, and we'll have also 5 minutes for eventual clarifications. Our discussant, Professor Rüdiger, will have 15 minutes too, just to discuss the presentation, and after his discussion, we will open a general discussion to the audience. Okay? So, I am excusing in advance to my Eastern colleagues. I will call them just only for Christian name, because, you know, as a Latin, if I have 2 consonants together, it's very difficult for me to pronounce correctly the surname. So, Irmina, good morning, welcome, and the floor is yours.
Good morning. Thank you very much for the introduction. My name is Miernicka, and thank you for the invitation as well. I hope you can hear me well, and everything from this technical point of view is okay. Quite challenging to open the session, but let's hope that everything will go smoothly. I have one technical question. Do you want me to share my screen with the presentation, or should I navigate with your screen?
You can share the presentation.
Okay, so I will share my screen with you then, and we will start. Okay, so I hope you can see it right now. All right, so my presentation refers to the right to disconnect as a tool to tackle inequalities resulting from remote working. So the COVID-19 pandemic has led in many cases to the relocation of workplaces to workers' home and to change the way they communicate with their employers. So remote working continues to be widely used in many businesses, and it is anticipated that more and more workers would be willing to work under this arrangement, and that more employers might offer it in the future. However, such working pattern frequently makes it difficult for workers to disconnect from work. The COVID-19 pandemic has greatly accelerated the spread of such work organization across different industries. At the same time, workers have felt a greater need to be involved and available, often excessively, as they fear they might lose their job. So here is the outline of my presentation. First, I will shortly describe the risks that may arise to the equality at work when working remotely. Then I will give you some general information on the right to disconnect. And I will also describe the right to disconnect in European perspective. And last but not least, protection against adverse treatment. So first, risk to equality at work arising from remote working. So appropriate use of the digital tools has brought many economic and social benefits. Digital transformation, however, should be based on respect to fundamental rights and values, and it should have a positive impact on working conditions. Unfortunately, remote working may cause inequalities between workers and even lead to discrimination of specific group of workers on various grounds. This might have several dimensions, which you can see on the slide. So, firstly, remote working can itself constitute basis for granting less favorable working conditions. There may be situations in which remote workers for example, experience precarious employment conditions, are paid less, or are not entitled to some benefits simply because they use this form of work. Next, the spread of remote working can create a new obstacle, which is called housing inequality, as housing conditions are often perceived as problematic by remote workers. Inefficient space, accommodation conditions, poor telecommunication environment at home may result in a decrease of productivity. However, I would like to focus on another aspect of unequal treatment that may be induced. Remote working may cause increased workers' availability. The greater use of digital tools for work purposes has resulted in ever-connected culture, which can have detrimental effects on fair working conditions. As surveys show, those who regularly work from home are more than twice likely to work in excess of maximum 38 hours per week, and they are also at risk of resting for less than 11 hours between working days compared to those who work on their employer's premises. Additionally, such workers more frequently report working in their free time, and they are also more likely to work irregular hours. Unfortunately, the excessive connectivity is often seen by employers and by superiors as an advantage. It is expected and it is very often rewarded. Nevertheless, for some groups of workers, this is often not possible, and it can lead to them being considered as inferior or less committed workers. And this involves particularly women and workers with caring responsibilities, young workers, elderly workers, and workers with disabilities. Women are particularly vulnerable to economic and social impact of the COVID-19 crisis due to their still traditional role of caregiver and of the home and family. They spend more time than men in fulfilling caring responsibilities and more often work fewer hours in paid employment. The increase of remote working during the COVID-19 crisis can also pose a higher risk to workers with caring responsibilities, such as single parents, families with children, and families with dependent relatives who require care. Being engaged in some essential caring tasks make them less able to be constantly available and respond to contacts. Young workers, whereas, very often make up the majority of the occasional ICT-based mobile workers, and it is common for this category of workers to combine work with educational activities, to which they also need to devote sufficient time. And last but not least, being available out of regular working hours impedes the body's recovery mechanisms, contributing to some negative impacts on health of workers, which can be particularly disruptive for elderly workers and workers with disabilities. Once again, increase in connectivity at the workplace should not result in any form of unequal treatment or discrimination in terms of recruitment or career development. So one of the tools to prevent this might be the right to disconnect from digital tools. So what is this right to disconnect? It is called the new generation right, and it is a right which also has several dimensions. Firstly, it is the right not to engage in work-related electronic communications, such as emails or messages, by means of digital tools during non-work hours. Then it is also the right to undisturbed rest and leisure, rational limitation of working day, and the right not to be penalized when exercising the right to disconnect. And also it consists of the duty to respect another person's right to disconnect. Why is it so important? The development of these digital tools it was particularly highlighted by the COVID-19 pandemic, and it brings the burden of this continuous availability and may lead to blurring the boundary between work and private time. It also leads to physical and mental health problems, as well as to the disruption of this work-life balance. So remote working possesses the risk of information overload, ineffective cooperation, and social isolation. It brings also the risk of unpaid overtime. Now I will give you the short information, the general information on the right to disconnect in European perspective, so also in some European states. Because in some states there are already specific legal regulations on right to disconnect. In other, this right is subject to collective bargaining, and in others, discussions on the future legislations are pending. So here on the slide you can see France. In 2017, the right to disconnect was regulated in French labor law, and now it is subject of mandatory annual negotiations between social partners at workplace level when employing 50 or more employees. And France become the inspiration for other European countries which have legally guaranteed the right to disconnect, adopting their own way of regulating it, different subjective scopes or methods of implementation, such as Italy and Spain. This year also Belgium introduced the right to disconnect, but only for civil servants. In Ireland we have the code of practice for employers, so it is not a binding law, but it's some kind of guidelines for workers and for employers. And in Portugal, we don't have right to disconnect, but there are financial penalties for employers if they contact remote workers outside their working hours. In Germany, we have this corporate self-regulation model. It means that the right to disconnect is a subject of voluntary consultation of social partners. Okay, so development of digital tools have led also the European Parliament to consider this connection as an urgency for workers. In January 2021, the European Parliament presented a resolution with recommendations to the Commission on the right to disconnect, and this resolution also includes the text of the proposed legislative proposal, directive on the right to disconnect. Of course, this resolution, it's not binding. Also, I will tell you right now that it's not perfect, and it required some amendments as well, and some adjustments. And for sure, there will be more discussion on this, but it shows the concept which might be considered. The proposal of the European Parliament.
Still 5 minutes, less than 5 minutes.
Okay, so the proposal of the European Parliament covers all relevant elements which you can see on the slides, such as scope and definition, implementing measures. I will not go into detail with this because this is not the topic of the presentation. The most important thing from this proposal is the protection against adverse treatment. So the exercise of this right to disconnect cannot result in unequal treatment or other adverse consequences related to recruitment, career opportunities, or retaining employment. And the proposal of the European Parliament explicitly addresses the issue of equal treatment of workers and notes that the absence of a statutory right to disconnect may result in some workers being disadvantaged. Taking all these factors into account, the proposal introduces several tools aimed at protecting workers. And firstly, it lays down an explicit ban on discrimination against workers exercising their right. This means that workers will be protected from the negative consequences of being disconnected, while at the same time, employer will not be able to promote discontinuous availability. Secondly, engagement in the active protection of workers in case they enforce their right is required, and member states shall ensure that employers protect workers from any adverse treatment and consequences. Thirdly, it introduces a reversed burden of proof, and also the right to redress and access to swift, effective and impartial dispute resolution. Also, member states should lay down some rules on effective, proportionate and dissuasive sanctions. Last but not least, they are obliged to clearly inform workers on their right to on their rights and adapted measure. So to sum up, the right to disconnect might be of particular importance to the most vulnerable workers and those with caring responsibilities. There are, of course, many discussions if the right to disconnect should be regulated at all, and if it should be regulated, then should it be on the EU level or maybe on the national level. There are naturally many shortcomings of the proposal of the European Union, of the European Parliament, which should be discussed. However, without presuming which solution is correct, connect because it's not the topic of this presentation, I would like to note that we can also look at this right from the perspective of combating unequal treatment. Workers who cannot be available outside regular working hours because of family or educational obligations, health, or even financial constraints should be explicitly protected against unfavorable treatment. It can also facilitate combining the responsibilities with private and family life, and also in some cases may prevent these workers from quitting the labor market. Furthermore, proposed reversed burden of proof will make it easier to pursue claims in practice. And also attention should be drawn to the educational value. The very proposal of the directive is causing public discussion and in this way raising awareness of this problem. Thank you very much for your attention.
Thank you. Thank you for your presentation and to be in the time that was assigned. Kamila, do you want to add something or?
No, we will just continue.
No, okay. Is there any question or clarification about this introduction? Okay, so we can just go to the second paper. It's yours. And the second paper is trying to balance, I think, compares the European legislation and the recent amendment of the Polish labor law. Okay, so you are two. The first is your colleague Agata, if I understand. So both of you, you have 15 minutes just to share on equity basis. Huh?
Each 7.5 minutes.
Okay. Okay, the floor is yours, Agata.
Thank you very much.
Good morning, colleagues. Good morning, colleagues. First of all, I would like to thank you for the possibility to contribute to this great event once again. I regret not to be personally in Modena, but I would like to thank you, all of you, to allow me to contribute to this conference in this manner. Today, with Kamila, we propose to analyze the right to disconnect as offered in the legislative proposal of the European Union Parliament in relation to the remote work as offered in the currently discussed amendments to the Polish labor law on remote work. We suggest that the right to disconnect can be discussed from two perspectives. Equity perspective, closely related to work-life balance of employees, especially women who are more often engaged in care duties and therefore more exposed to remote work to ensure easier access to economic activity. In this perspective, we can say about the positive correlation of remote work with work-life balance, and protective perspective closely related with protection of the working time regulation that threats, because of the threats caused by the excessive use of digital tools in the working process that may invade the personal life of the employees and blur the boundaries between the private and the professional sphere of employees. And under this perspective, we can say about the negative correlation of remote work with work-life balance of employees.
new regulation of remote work. And in May last year, 2021, our government legislation center published a draft act that is supposed to regulate and introduce the remote work regulation into our labor code. And it is the first time that remote work has been regulated during the pandemic, but only in a temporary way, in a special so-called COVID Act with particular pandemic provision, and we have never had the remote work regulation in our labor law before. At the same time, the European social partners and the European Parliament have been examining the implication of the technologies and digital tools and the remote work on working conditions, on the physical and mental health of the workers, on the health and safety at work, work-life balance, and also the always on call and always available working culture. And what we have seen as interesting is that from the proposal of the European Commission, we can see that the European Parliament has indicated that the right to disconnect is a response to not only the problem of gender equality, and that the gender equality perspective needs to be taken into consideration while discussing right to disconnect, but it's also a tool to protect the working time regulations and the work-life balance in the digital working environment. So when we have compared these proposed regulations at the European level with existing regulations in Poland and the proposed new regulations that add to introduce remote work in a proper manner into Polish labor law, we have noticed some threats, especially because of the fact that in our proposed regulation of remote work, the question of right to disconnect has not been addressed anyhow. So this is an important drawback of the proposal, because also in Poland, while we have been examining at the European level the consequences of the remote work during the last 2 years of the pandemic, we have seen and we have noticed the same threats, the threats for gender equality, the threats of the work-life balance and exaggerated working time, and the consequences for the working culture of the workers. And because of the fact that in the existing regulations and the proposed regulations, we don't have a right to disconnect, and it has not been discussed between the social partners, we needed to examine the existing regulations of the remote work in Poland, and the existing regulations, the general regulations of the working time. So when we think about the problematics connected with the right to disconnect and the possibility to apply the right to disconnect in Poland, it has not been introduced as a legal measure, but if we lack the specific regulations, we apply the general existing regulations on the working time, on the overtime, on the rest period, also on the monitoring and control of working time. And what is interesting from this perspective is that when we compare our regulations of working time to the jurisprudence of the Court of Justice of the European Union, we see that the possible problems that occur would include the on-call and standby time, and the possibility of the employee to refuse to the command to work overtime if we consider the right to disconnect as also a protection against the overtime, especially considering the caregivers. And it's also a problem when we don't have the
proper right to disconnect, and we only analyze the existing regulations on the working time, that generally to measure and monitor the time of work, it's a general obligation of the employer, but only in the basically in one case in Poland, in the task-rated system of working time, only the employee would be obliged to monitor its working time. So this also might be a problem to prove, if even we considered the time that we are connected after normal working hours, how to prove that it is working time and that this is already overtime, and the question of monitoring and measuring these calls. We also have an interesting case law in Poland considering the on-call and standby time, whether it is considered or not the working time. So this is also a problematic question, and the other question connected with this that we won't discuss today is also connected with the right to remuneration for the standby time and on-call time, but this is another topic. So concluding in a very short way, concluding our analysis from the point of view of the existing regulations, we have noticed that there are some interesting perspectives and problems connected with the existing regulations, with the proposed regulation that is not not entering into our regulations of working time, of overtime, and on the work-life balance in case of and regarding the remote work, because these questions are not addressed in the proposal. And I give the floor again to Agata.
So our analysis, as Kamila reveals, our analysis ends with the conclusions that neither equity nor protective goals of the right to disconnect from work may be possible to achieve under the proposed legislative changes to the Polish labor law on remote work. Our analysis reveals some limitations, as has been indicated, of the proposed legislation as regards the effective execution of the right to disconnect from work, and consequently the implementation of the purpose that lies behind of the legislative proposal of the European Parliament. As Kamila indicated, connected with this proposal, in this proposal, the European Parliament indicated that the right to disconnect ought to be seen not only as a tool to protect the working time regulation, but also the gender equality and work-life balance in the digital working environment. So in this context, the main shortcoming of the proposed legislation is a general character of the regulations on working time that apply to remote employees on the same basis as to employees that provide work in a traditional manner, that take no account on particularities of remote working and the threats it might cause for a personal life of employee. The lack of legal measures implementing the right to disconnect, so the lack of the specific right to disconnect in the proposed legislation, creates a great uncertainty for employees as regards the possibility to refer to the right to disconnect from work in relation to the overtime and rest periods. That in many cases, as regards the overtime and rest periods, can be ultimately effectively claimed in court proceedings in labor law matters, but only in relation to this general working time regulation. Last but not least, the proposed legislation is addressed only to employees who provide a remote work under an employment relationship. So it is not addressed to the workers who provide the work outside the employment relationship. The reference to the effet utile argument of the legislative proposal of the European Parliament serves a reference point to control a nationally accepted definition of worker, when implementing proposed European Union legislation. But of course, it is the this fair for the another analysis for which there is no time during this discussion. So. So to conclude, we've seen a lot of shortcomings as regards the proposed legislation to the Polish Labour Code on remote work, as regards the European Union proposal related to the right to disconnect from work. Thank you for your attendance, and we are open to the questions related to our intervention. Thank you.
Thank you very much for your introduction and for managing efficiently the time assigned. I have just only, there is some clarification. I just want to only make one point. Is if I understand the eventual changing in the Polish legislature about work is making Poland more distant rather than more closer to the European legislation. Is that right?
Yes, I think that our main point is that our new proposed regulation of remote work that should introduce the specific regulation of remote work into our labor law is not addressing at all the risks that have been indicated by the European Parliament in the proposal on right to disconnect.
Okay. Well, if there is no clarification, I think we can just skip to the third. Thank you, Agata. Thank you, Kamila. And now.
Hello, good morning. I'm afraid I don't hear anything coming from the room.
Okay.
Now it's better. Okay.
Okay. Just I remember that you have 15 minutes to introduce your paper, and so now the floor is yours. And go ahead.
Okay. Thank you very much. So first of all, good morning again to everyone, and then thank you for having me here. Last day we mentioned quite many times during the different sessions that COVID is still real and among us. Now I'm the best illustration. I was infected this week, so that's why I cannot be with you. Luckily, my most severe symptom is that I'm deeply sad that I cannot be present in Modena right now, but otherwise, I'm really glad to the organizing committee that at least through this online platform I can join the conference. And the topic I'd like to talk about is how the rules of working time are shaped or questioned from the aspect of working time autonomy. Autonomy is a very often used term concerning working time in the digital era, that employees now can have more influence on deciding how much to work and when to work. And I'd like to explore how this shall have an effect on our existing regulations. My starting point is that if we understand working time autonomy in a strict way, then this concept is quite hard to achieve for most businesses, for most employers. In this strict sense, working time autonomy means that the employee can decide when to work and how much to work. So both the measure and the schedule of working time can be decided by the employee, him or herself. And from this sense, working time autonomy presupposes three conditions, and this is what you can see on the slide. And this is the assumption that paid work is always available. So if an employer builds its organization on the principle of working time autonomy, this means that this employer shall guarantee that whenever the employee wishes to earn money, there will be a task available. This is the slogan very often used in gig work by online platforms, that if you want to make extra money whenever you feel like that, you can log on the application and there will be a task waiting for you and you can earn money. From another aspect, the same employer shall have a very robust workforce available, because if my employees can decide when they want to work, from the aspect of my users, from the aspect of my customers or clients, my business can only be successful if I can guarantee that there will be anybody, or at least someone, at any time who will be present to the disposal of my clients. And there is also a wage aspect of working time autonomy, which means that freedom over the temporal aspects of employment is not enough if at the end of the day the employee cannot make ends meet from the wage earned from that employment. So working time autonomy also has this wage element, that a decent wage is available, is reachable from the employment. And if you see the literature and the empirical evidence on how most employees work in these new forms of employment or in digital contexts, it's quite apparent that for most of these people, working time autonomy understood under these three aspects is not reality. Maybe a partial autonomy can be reached by them, but not a full autonomy. There are researches conducted by the ILO, Eurofound, the European Trade Union Institution, OECD, and a lot of research centers. And from this enormous empirical evidence, we can gather a lot of problems or doubts whether autonomy is reachable in these digital work forms. For instance, I just collected some keywords from these studies. For instance, if we see the first assumption that for autonomous workers, paid work is always available, just think about waiting time. Waiting time is a huge issue for gig workers. They might log in their applications and wait for a task to do, but in fact, in reality, they spend quite much time with slowly waiting for another customer or client to show up. Or just my Polish colleagues told a lot about telework and the doubts whether telework is really the golden age of work and life balance. Empirical evidence suggests that this might be the case. There is evidence that teleworkers actually perform more work from home than they used to do when they worked in the office. The pandemic showed quite a lot of examples of that. If you turn to the second aspect, if the employer has to have a vast pool of employees, this also means from the aspect of the workers that there is an enhanced competition among them. So they compete with each other for the tasks. This is very apparent in case of crowd workers or in online platforms which work globally. So where the work shall not be performed physically in a given area, but it is done online, then actually the whole global labor market can take part, and all workers around the globe can compete for a given task. And as for the wage aspect, research shows that in many cases these flexible schedules and 0 hours contracts come with income insecurity, and only low wages are available. So again, even if that in some instances employees can have strong influence over their own schedules and the measure of working time, if this employment cannot come with a decent wage, then it is still to be considered as precarious, or at least some form of precariousness. So to conclude all these studies, or to summarize the lessons learned from these studies, my point is that it seems clear that technological change alone in itself will not bring working time autonomy to anyone. What we still need is the decision of the employers that they are actually ready to relax some of their rights to control the employment. Or in many cases, it's not just the will of the employer that the employing entity can relax control, but it is also the ability, the question of whether employers are able to relax the control over how the work is done or when the work is done. There are a lot of activities in practice which, even in the modern era, need this strong control over the employment relationship, or over how the work is done. So if you think about manufacturing or healthcare services, where the service shall be provided on an uninterrupted basis, these activities cannot be really organized otherwise, but with the strong control of the employer as regards the temporal aspects of employment. And if you see how this concept appears in European law, there is one article, actually one subparagraph in the Working Time Directive on autonomous workers, which defines these workers as that they have some specific characteristics of in their activity, for which the duration of the working time is not measured, or it can be determined by the workers themselves. If that's the case, then the Working Time Directive offers quite a long list of possible derogations: daily rest, breaks, weekly rest, the maximum weekly working time, the measure on the length of night work, and the reference periods can be deviated from. But member states shall still respect the basic principle of the protection of the health and safety of workers. So the concept in the European law is the same. Like if employees have more influence over working time, then they need only lesser protection, less high-level protection as regards working time. Which is quite interesting is to see how this concept appears in the court practice. There is some case law available, how this concept is interpreted by the European Court of Justice. And the key word is that the European Court of Justice explains or explores this concept in a very narrow way, in a very strict way. What the court said is that autonomous workers are only those people who enjoys this full autonomy, where the working time as a whole is not measured or determined by the workers themselves. Now, this wording that working time as a whole shall be determined by the employees does not appear literally in the text of the directive, but the court decided that it is evident that it shall be understood that way. That's quite a short, laconic reasoning, but in the later cases, the court always followed this path. There was a second case involving university lecturers, where, again, the national law closed these people from the protection of some working time protections, working time regulations, and the European Court of Justice ruled that these people could not be considered as autonomous workers because they did not enjoy full working time autonomy, as their employment contract contained some provisions on the measure of the working time. So it was not full autonomy on the side of the employees. And there was also a third very interesting case, which concerned so-called relief parents. Relief parents were employees who actually substituted foster parents who took care about orphans and other children who had no families. And it is a very special activity. Of course, there was a quite reasonable level of autonomy involved. for the employees, but here the court followed a very detailed assessment on the working conditions of these people. And finally, the court concluded again that as some aspects of the working time were not decided by the employee, but it was controlled by the employer or stipulated in the contract, then those people could not be considered as autonomous workers. So following this very strict case law, the question is whether is there anyone in the European labor market who could fall under the concept of autonomous worker as understood by the European Court of Justice. Because even if a top executive employee has to be present in certain meetings or trainings ordered by the employer, now even them cannot be considered as autonomous workers because they are not enjoying autonomy in full. Their working time as a whole is not determined by themselves, but at least with rare exceptions, working time can be also scheduled by their employer. So it's probably a too strict approach from the side of the court. And to sum up, basically, autonomy as regards working time is not just a single concept, but rather a scale. One endpoint of the scale is where the employer exercises full control over the temporal aspects of employment. The other endpoint is where it's the employee who can fully determine all questions concerning working time. And most cases in practice fall somewhere in between, where the employee has some level of autonomy, even though it's not 100%. And for us labor lawyers, the question is which is the point from where or until where the labor law regulations shall apply, the traditional protections of working time regulations shall step in. It's very hard to answer that question. Just as a conclusion, I just try to make some conclusions to answer that question. First, what I find important is that even when an employee performs under the full control of the employer, this shall not be considered as something detrimental to the worker. So autonomy is always considered as an aim or as something which is very beneficial for the employee, but also an employment relationship falling under the very strict working time regime can be beneficial for an employee if it is coupled with employment security, if it is also coupled with income security, where my schedule is absolutely foreseeable, I work the same amount of time every day. It might be very strict and fully controlled by my employer, but can offer also some advantages for me as a worker. If you see the other endpoint, what is interesting here is even if the employee has full autonomy, this does not mean that no protection shall apply. So if you see the European Directive on Working Time, there are vast possibilities to derogate from the directive, but like annual leave or the protections of night work shall still apply to autonomous workers as well. So full autonomy still does not mean that all working time protections are lifted and nothing applies. Also, other institutions from other directives like maternity leave or parental leave shall apply to autonomous workers as well. And a basic principle concerning working time is always the protection of health and safety of the workers. That's the basic assumption between this whole body of regulation. So in the whole system of the directive and European law, whenever you derogate from a certain working time principle, you shall still respect somehow this basic principle of the protection of safety and health of the workers. So it's never the question of just an opt-out, like parties can decide not to apply a certain working time protection, but there seems to be something alternative solution to offer the same equivalent level of protection. And that might be the concept in all these cases falling between the two endpoints. Labor law protection shall be proportionate of the autonomy enjoyed, or the control still suffered, let's say, by the employee. And we should never forget that the basic assumption behind working time is always the protection of health and safety. Thank you very much for your attention.
Okay, thank you, Gábor, for your introduction. Is there any clarification, please? Tommaso? Come here, it's better.
Okay, thank you, Gábor. Just a comment. I appreciate. I think you made an important claim. I think that the notion of autonomy is one field for interesting interdisciplinary reflection. We have done some here at the Foundation with the colleagues from Labor Law. We are somehow familiar with a theoretical approach that says that either you have it or you don't have it. So autonomy is kind of a binary, and any other situation where you have some opportunity for choosing within a regulated context, it's discretion. So I think we don't have the time to go into this now, but I think that I found very interesting your claim and also the need for a better interdisciplinary understanding of the notion of autonomy. That's it. Thank you.
Okay, I want just to make another comment. If you, what is the degree of the intensity of autonomy that does not change the subordination contract, because we have to remember that the entrepreneur is bearing all the risks, and this is the basis of the legitimation of authority and control over the working time of the worker. So when you just has a slide where you have just put the range of autonomy, I'm asking you if you have some idea of what is the point of this in the scale that just does not change the subordination worker relationship and just change the nature of the working relation in the full autonomous worker, okay?
Well, I think that's a very complicated question to decide, and it could also only be decided with the full consideration of all working conditions. So, because in most cases, one or two elements of working time might be flexible in a given employment, but the others could be still controlled strongly by the employer. So a holistic view shall be followed in each case, and it probably cannot be decided otherwise, like a case-by-case approach. And to think about the scale I showed you, I think there are only two clear points in that scale, is the two endpoints. Like, it's quite clear what does it mean when the employment is fully controlled by the employer, and what does it mean when the employee has full autonomy. But everything in between becomes quite blurry, and probably you cannot say that it shall be the middle point of the scale from where labor law protections shall apply, and everything beyond shall be considered as autonomy or even a civil law contract. Probably that point which changes the whole game cannot be decided with such mathematical concreteness, but only with this case-by-case approach.
Okay. Well, now it's time to discuss the three papers, and this will be done by our colleague
thank
Rüdiger.
you.
And so the floor is yours. I don't know.
Is
I think it is good.
okay. Yeah, thank you, Luigi. And thank you to the 4 presenters. All the 3 presentations show us that the title of our session, New Organizational Patterns and Implications for Working Time, is in some dimension absolutely right, but perhaps a bit too narrow. It's right in that sense that it's not about technology as such, information and communication technology, but on the organizational patterns, how to organize work. That is the decisive point. But it's too narrow in that sense that it's not only about working time and what's behind working time, health and safety issues, but also work-life balance. And in particular, the Polish colleagues have emphasized this equality aspects. That's also a very important point. Gender equality, but also other inequalities. For instance, the inequality between different groups of employees, those who are more, let's say, committed to technical issues and who have no problems to work more or less the whole day, and the others who are not. And so we face the problem of perhaps peer group pressure, and I'm very grateful to the Polish colleagues that they put also some emphasis on this point of view, not only on the protective aspect. Well, I will start with, and I will bundle the Polish 2 Polish presentations together, the right to disconnect, and then turn to Gábor with the working time aspects in the very challenging concept of autonomy. Tommaso has raised the problem. Well, starting with the right to disconnect, the first point is, and I think it's very important to realize and to assess the socioeconomic situation. The right to disconnect is an instrument, a tool to solve particular problems, and the first, of course, has to be an accurate analysis of the real situation, and then we can, in a second place, assess which instrument is useful and helpful to solve the problems. And the first point is that we should perhaps not start with only with the risks, and also the proposal of the European Parliament says, well, remote work is at first place, it brings benefits for the employer, more efficient work, perhaps more productivity, more flexibility, but also benefits for the workers. So the point is not to, and nobody wants it, of course, to abolish remote work or to draw it back, but to organize in a way that the gains can be materialized and the risks are pushed back. So that's, I think, an important point. And we have also the somewhat paradoxical situation that work-life balance is on both sides. Work-life balance can be enhanced. A better work-life balance can be enhanced by remote work with the help of ICT. But on the other hand, it can be organized in a way that it is detrimental to work-life balance. So this paradoxical situation, it could be perhaps a bit more emphasized in the perhaps a final version of the papers. So it is an organizational problem, and perhaps a problem of the, let's say, the disorganization of work. It's not a question of an accurate organization, but a leeway, a situation in which work is not organized properly. So we should also take this in mind. Well, the solution is, the right to disconnection. Its core, it's an instrument to cut work life on the one side and private life on the other side. I would say this is, it might be that this view is a bit too, well, it does not embrace all the problems. In particular, if we focus on that, what we call constantly availability by the employer, by superiors, by clients, and so on, or colleagues. because it has the impression that the employer is at home and at the request of other persons. But we should also keep in mind that we have this phenomenon of what we can call the voluntary work outside of the official working times, that even if all the emails are coming on the email account of the employee within the working time, if he works voluntarily on that and gives answers in the evening or in the night, or prepare a presentation to meet a very urgent deadline for an article, then it is not only about the disconnection of or the cut of the availability of the employee. We should also, I think, keep this in mind. And so the question is the cut between private life and work life, is this the only solution for that? Or do we face a situation in which the work is intensified because the real problem might be an overworkload, too many work to do, and an understaffing. And we should consider about the question, if we use a tool to tackle problems, but we tackle only the symptoms and not the sources or the drivers for that development. Well, coming now to the right to disconnection in a more technical sense, it is very useful in the first paper that the development is described. First, it started with the case law in France, developed by the Cour de Cassation, 2 decisions 20 years ago or so, then adopted by the legislation in France, and then spread over Europe. For me, a very interesting development or example for the point that some new ideas are developed, at least in the legal order, by courts. And this means that courts cannot decide, in contrast to politicians and the legislator, by themselves. They must have a case, otherwise they cannot decide. And so the question is how to come to new developments in case law. That means, and I will touch only the point, strategic legislation. You need, in some situations, persons or trade unions or works council or whatever you want, persons who are actors who bring a case, a particular case, to a court, and then, with arguments, to develop a new, further development of the legal order. And then it might be that some years later, the legislator adopted that because the solution is convincing. Well, now turning to the proposal or the European level, I will start with the social partners agreement. It's also mentioned in the papers. Because the wording of this paper is in some respect a bit, or the wording is a bit reluctant. They do not use directly the right to disconnect. It might be, a compromise, compromise between the social partners in that respect. But I think it's very important that they undermine or emphasize the responsibility of the employer to do this. And the question that the workload and the number of staff should be, aside more or less the wording, should be evaluated jointly. This is a very interesting point, because normally employers, in my view, are very reluctant to accept any let's say limitations or restrictions as regard the hardcore managerial prerogatives. This is staff. This is the question of workload. Other things are perhaps not so important, but this is very, very, very hardcore. To realize or to accept that the problem of connection and disconnection is not only a technical question, the question of how ICT function, but is a question of workload and the question of the staffing. This is an important point. Well, the implementation of this agreement should be made within 3 years, and of course there is the proposal of the European Parliament, and they realize that normally the social partners are the fore, and they have they are the first mover, and unless only in that case that there is no properly implementation of this agreement, then the legislator at the European level should act. Well, I will not go into the details of this proposal. You have described it very, very accurately. Only perhaps one or 2 points. One thing is establishing a right to disconnect. The second point, and the proposal is very detailed in that aspect. The enforcement and the question measuring of working time is also a very, very important point, because if you do not measure working time, then a right to disconnect is more or less it has no real basis. And the second point is very detailed provisions or proposals as regards the protection against adverse treatment. However, the question is this enough? And the point is an individual right to disconnect must be practiced and must be enforced. And the point is, do we need once again organizational regulations at company level, at plant level? And of course, the legislator cannot provide details in that respect, but to put a bit more emphasis on the question how to bring it on the ground, this would be, I think, useful. And the social partners activities, mainly at the plant or the company level, are, I think, in my view, the best way to implement and to effectively implement such a right. It is not helpful and not sufficient to have a right only in the books. It must be practiced, so social partners, examples and agreements will help in that direction. Last thought, coming to voluntary work. The question is, what is in situations in which an employee does not want to be disconnected because he or she is absolutely dispirited of the work he or she is doing. The question is, should the legal order intervene into this situation? What is the free will of the employee in that situation? We come to the problem of paternalism. And the point is, can we argue from a more, let's say, subtle point of view? Are there long-term preferences? If you are young, you can work 10 hours, 12 hours, 14 hours a day. If you are older, that could be a problem. And the point of external effects, you mentioned, I think you mentioned it, the pressure between different groups of employees. If the strong group of employees who is maybe able to work more than 40 or 50 or 60 hours a week, self-employed persons can do this without any problem, without any legal problem. Is there a pressure on other groups of employees, and should the law intervene for that kind of reason because of the external effects of the own behavior? I will only touch the point. It's a discussion in itself. Well, let's turn now to Gábor. He started with a claim that working time, not his own claim, but the existing claim, that working time regulation is outdated, does not fit into the brave new world of new work patterns. It's interesting, I remember a German PhD thesis 1 or 2 years ago in which this claim is made, and the solution was to say, well, we should withdraw working time regulation and come more to, well, health and safety as a core of working time, and the solutions should only be to have a more or less general framework. Work should not affect health and safety, that's absolutely clear, and so we should work more with risk assessments and something like that, so go away from this strict regulations which we have in this working time directive. Well, that's of course not the view of Gábor. And he said two things at the beginning. First, even the traditional employment relationship has some kind of, or some elements of autonomy. So it's not totally new, the problem we face in that in this situation. And the traditional, or the often heard argument, everything is new and so we should abolish labor law, this is more or less only a strategic or rhetoric argumentation. And also the working time, the existing working time regulation, the directive, is extremely flexible. If we go into the details, there are a lot of possibilities to derogate from that, mainly by collective agreements. And this is also the point, if collective agreements or the coverage of collective agreements is decreasing. It's this situation in Germany, I think in Hungary may be the same, perhaps in Poland too. The question is that the employers could not use these derogations because they avoid to conclude collective agreements. So it's their problem, and because the options are there. You must use collective agreements, but this means that you must bargain with employee representatives and you cannot act unilaterally. Okay. As regards autonomy, well, a great word, a great concept. I don't want to dig too deep into that. The point is, Gábor tries to analyze what does real autonomy would mean in the world of work, and this does not really work, or this does not really function in an economy in which enterprises must be successful. If all the employees can decide how to work, when to work, if to work, or whether to work, that would not be reasonable. So a full autonomy does not exist, and this is an argument in that way that we should not go perhaps too strong into that direction. Turning back to the working time directive and the particular, Article 17, the autonomous workers, it might be that there is some kind of tension in this paper, because in the first part, Gábor emphasized the flexibilization potential of the working time directive, but as regards the case law of the ECJ, the notion of autonomous workers is more or less not existent, because the requirements are so high that nobody in Europe will ever meet these requirements, and so it could be the question: why does the ECJ interpret Article 7 in a so rigid way? It might be that in the background is the health and safety issue, or perhaps Article 31 of the Fundamental Rights Charter. I do not think, or I haven't in mind that they cited it directly, because the cases are a bit older, but I do not know. Well, at the end of the place, and if my statement, I fully endorse that what Gábor said, that the working time directive is not outdated, not out-fashioned. It could be still a useful instrument to regulate also remote work. There might be some, as regards the interpretation of Article 17, that's more or less a detail, that the appropriateness of let's say discretion, if you want to avoid the term autonomy, discretion on the one side and regulation on the other side, there should be some kind of proportionateness. But the last point is that we should also take in mind, or keep in mind, one thing is to apply the law, or the applicability of law as such, but the other thing is the enforcement and the implementation. And this is also in labor law traditionally a large problem, a big problem, and we should, in particular as regards working time, see that this problem must also be solved, not only the applicability of law as such, but also the implementation into the practice. Okay, thanks for your attention.
Okay, thank you, Rüdiger. Okay, we have 15 minutes just to discuss, so I open this opportunity. So if there is somebody who just want to make comments, questions, or whatever.
So then, perhaps I can ask a question to the Polish
Sure.
Okay. My question would be, well, your proposal is to implement something like a right to disconnect in the Polish law. I'm not, haven't read the text of the Polish proposal, because I think it's not, the text as such is not translated into English. It's Polish. Yeah. Cannot read this, but well, if your proposal is to implement such a right, is there any idea to come to let's say social partner agreements to implement this right? In my view, a mere individual right is better than nothing. Of course, you need it as a starting point, but to have a mere individual right and say, okay, you as an individual employee have to enforce it, I think it could be problematic for employees to sue their employer during the employment relationship. Normally, this does not happen.
Just wait a minute. Microphone.
Okay.
Okay, thank you. Of course, if my colleagues online would like to intervene, I invite them also to support what I will say. Well, from my point of view, I agree more with the social partners agreement on the European level, and they have proposed, and I really liked the part of the proposal when they propose non-legal measures to implement the right to disconnect, such as changing the working culture or educating workers about the organization of work. In case of remote work, it's also more often the self-organization of work, also the interaction between employees at different levels, not only with the employer. So I really support the idea of introducing some organizational non-legal measures at the company level, and they also propose to regulate it, as in different European countries already is happening, the right to disconnect, or maybe better to say the ways in which we connect, or the ways in which we use digital tools, because it's not the cut-off that is the problem. It's the proper use of the technology that should be addressed. And they propose collective agreements and collective bargaining as a response, but unfortunately from the Polish perspective, it probably wouldn't happen. So this is the question, how to implement in practice the right or the protection against some particular risks that have been identified in our Polish reality without legal measures or without acting as a legislator. So this is also a question that we ask ourselves. And the proposal of the remote work, we didn't maybe characterize it in a detailed way, but what is the most interesting for us is what the proposal is missing. So it's not what in the proposal, but it's what is not. Thank you.
Okay. And do you think that, well, does Poland have a, let's say, a functioning system of industrial relations, so we can, you can rely, if the right to disconnect will be implemented in the Polish law, it would be put on the would be brought on the practical level of companies and plants, or is it at the end of the day the responsibility of the single employee to enforce that right?
Maybe I will give the floor to Agata, because I see that she's also connected.
Because this is, I think,
Okay, so
it's a crucial point.
Okay, so under Polish legislation, of course, we have a trade clause for the. Okay, so is okay. Okay, so under Polish legislation, we have a regulation that allows social partners to regulate the right to disconnect on the company level, but in reality, I believe that that the right to disconnect should be regulated on the more general level in the labor law, because without the regulation in the labor law, I think that I don't know what Kamila think about that, but I believe that without the general regulation in the labor law, the right to disconnect will be not enforced reality, or it would be only related to the limited group of employees who had a very strong bargain power to enforce this right individually related to them. But I don't think so that it will relate to the more broadly group of employees. Thank you.
Of this regulation instead of the execution, as you were asking, of the individual right by an employee filing a claim against his employer. So I would opt for the prevention, for the education, for the organizational measures in order to prevent some risks. But I think that, as Agata said, introducing this regulation into the labor law would also have this prevention power. It would be another asset to consider while organizing the working time. But yes, the execution of this right would be a different question, because it's the general question also of the execution generally of the individual rights of employees in labor courts. But it's a harsh and long discussion. Thank you.
Okay. Any other comment?
About what happened to the disconnection legislation in Germany. Can you tell us something about? I heard that there's been some tests in Volkswagen, in one labor ministry maybe, or I just wanted to know what happened about the disconnection legislation in Germany, if you have some good experience.
Yeah, discrimination or? No.
Disconnection.
Disconnection, okay. Sorry. Well, yes, some of these, let's say, examples from large German companies, Volkswagen was one example, or Daimler-Benz, they had also had it, and they go through the media because it was very spectacular that there was some kind of a shutdown of servers on the weekend, but only for more or less for the rank and file workers, not for the top management, of course. I haven't, and it was also, I think at Daimler, they had the, maybe for some period, I do not know if they perform it now, that emails are more or less deleted if emails are coming from other persons during, let's say, off times. And I would say this is not unproblematic, because the other person, maybe another employee of Daimler, must write the mail once again, because it's gone, and this is of course also additional work. So the workload is increasing. Well, yeah, there are many examples, and there are also let's say collections of not so spectacular works agreements on this. Most of this is of course on the level of the company. It's not possible to regulate this at a sectoral level. You must have the concrete situation keep in mind and see what technical devices are used in a particular firm. That's of course very different. I do not know if there is any, let's say, assessment, research assessment of this. I haven't heard of this. There are perhaps some studies of the Federal Labor Ministry and examples for best practice and so on.
So the point was, do you think that it is somehow effective in regulating the cut between private life and working life or not?
Yeah, that's the point. Is it really effective? I think there is no empirical data on this. The affected companies or employees are more or less satisfied with that situation, but and I would say this is at the end of the day the most decisive factor. Are the people, the real affected employees, can they cope with that situation, and not the question is a law professor sufficient or confident with that what's going on. There was also in BMW something like that, or mobile work arrangements in other companies, and at the end of the day it works, but there is no, as I know, no overall assessment on the question with surveys and let's say polls also, if all affected employees can live with that. Apparently it works, and if there is no complaint, and we do not, that's maybe one hint, we do not have, I think, only one decision, decision of a court in which these questions are touched. There is no litigation on that, and this might be, you can say, well, no litigation because the employees are reluctant to sue the employee, but in this respect, my analysis would be, or my assessment would be, it works. And if things work, I think it's not absolutely necessary to intervene in this field.
Okay. Any other question? Please.
Thank you very much. I would like to question what you last said, that it works, because when you see at the numbers of people who are struggling when it comes to achieving work-life balance, in particular in the last 2 years, I would rather say that they are not able to cut or draw the line between work and private life. And it's also a question of responsibility, namely of people who are in a responsible leader function, that I'm as a leader, for example, in a company, that I'm not sending an email during the weekend to my employees, even though they might have the right to disconnect, because that might set the employees under pressure to answer. And so it's...
Yeah, well, that's a bit to clarify my position. I would not say that it is not necessary to do anything. The point is, if there is a functioning collective agreement, the point is how do we come to feasible solutions? Is it sufficient to have an abstract act which says, well, you have a right to disconnect and that's all? I would say no, this is not sufficient. You need indeed change in the culture, you need a change in the way to organize work, and you need well, in most or many situations, collective agreements which regulate in a more or less detailed way how to cope with things. But it's not, and this was my point, an act which only says, well, no problem, you have a right to disconnect. That's not sufficient.
Yeah, okay, then we are on the same page. Because if you, for example, compare to the development when it comes to discrimination law, it wasn't sufficient for the companies just to say, yeah, we do have a diverse company culture, we do not discriminate. Yeah, the employees de facto needed the right not to be discriminated against for several reasons and to enforce it. Yeah, and otherwise, if you, that's the thing we are just now struggling with, that companies just have diversity and inclusion management, like it's window shopping. It's nothing else. And so you really need to have, as you said, not only the right, but also you need to have to work on the.
I think a very, very important point. I will come to, and I think we have some minutes for a discussion. For instance, data protection law, that's also the same. There are a lot of data privacy violations in companies. Normally, the employees do not sue the employer during the employment relationship. Most cases, data protection or data protection law violations are come to the courts when it comes to the termination of a contract, and then within the litigation on the justification of the dismissal, then the question was raised: was it lawful for the employer to detect, let's say, some kind of a violation of the employment contract? And so at the end of the day, but not at the beginning, if data protection. And the idea is or the goal should be to come to it in a very early stage to avoid any violations and not to cure them if they have occurred. And it is apparently better to come, let's say, to Germany Betriebsvereinbarung, works agreement, which in a very detailed manner says, well, which data can be collected, for which purposes, and who has the access to the data, and so on. Because then you have a clear regulation. You have a commitment of the employer that he has subscribed it, and then the Works Council can say, okay, if you subscribed it, you should comply with this. This is also a problem, of course, because reality is very complex. But I think it's not a question of either or, but it's we have to see if we want to influence social practices. We have at the top some kind of law, but this is only one side of the story, or one part of the story. We need also with the changes of social practices at that place where work occurs, where work happens, and this is at the company level and not in the parliament. Well, this is my stance.
I think that we can just finish, and so thank you for your participation, and the session is over. Thank you.
Yeah, it was very good. Thank you.